Hi everyone, welcome to Legal Talks by Desi Kanun. I am Suyash and today I will discuss the case of Sivasankaran versus Santhimeental, wherein the Hon'ble Supreme Court discussed the broad contours under which a decree of divorce could be passed directly by the Supreme Court of India without referring the parties to the family court in exercise of powers under Article 142 of the Constitution of India. The facts of the case are not relevant for the purposes of this show, and hence the same are not being discussed. Before adverting any further, let us briefly go through Article 142 of the Constitution of India. It provides that the Supreme Court has the power to pass any decree or order for doing complete justice in any cause or matter pending before it. Now, whether this power encompasses the power to pass a decree of divorce or not is a question that was answered by the court in the present case. Thus, let us discuss the important observations by the Supreme Court. Firstly, the court noted that irretrievable breakdown of marriage does not exist as a ground of divorce under the Hindu Marriage Act or the Special Marriage Act. Thus, in such light, the Supreme Court has granted decrees of divorce exercising its unique jurisdiction under Article 142 of the Constitution of India to do complete justice between the parties. Secondly, the Supreme Court explained that it has granted decrees of divorce to put a quietus to the matrimonial dispute in cases where the parties themselves accept irretrievable breakdown of marriage. The court admitted that it has to walk a tightrope in cases where only one of the parties is willing to acknowledge irretrievable breakdown of marriage and the other is not. Thirdly, the court also observed that under the Hindu law, marriage is a sacrament and is ideally supposed to be an eternal union. Further, the social acceptance of divorces in India is quite low. Thus, it is also in this light that the Supreme Court occasionally exercises powers under Article 142 to grant divorce. Fourthly, the court discussed the idea of marriage by stating that a marriage is more than a seemingly simple union between two individuals. As a social institution, all marriages have legal, economic, cultural, and religious ramifications. The norms of a marriage and the varying degrees of legitimacy it may acquire are dictated by factors such as marriage and divorce laws, prevailing social norms, and religious dictates. Functionally, marriages are seen as a site for the propagation of social and cultural capital as they help in identifying kinship ties, regulating sexual behavior, and consolidating property and social prestige. Families are arranged on the idea of a mutual expectation of support and amity, which is meant to be experienced and acknowledged amongst its members. Once this amity breaks apart, the results can be highly devastating and stigmatizing. The primary effects of such breakdown are felt especially by women, who may find it hard to guarantee the same degree of social adjustment and support that they enjoyed while they were married. Fifthly, the court clarified that though a reference petition in relation to exercise of powers under Article 142 to grant divorce decrees where there is mutual consent is pending, yet in cases where there is no mutual consent of parties, there is nothing that bars the court to dissolve a marriage on the ground of irretrievable breakdown of marriage in exercise of powers under Article 142. Sixthly, the court cited the case of Hitesh Bhatnagar versus Deepa Bhatnagar to explain that courts can dissolve a marriage as irretrievably broken down only when it is impossible to save the marriage. All efforts have been made in that regard. The court is convinced beyond any doubt that there is actually no chance of the marriage surviving and it is broken beyond repair. Seventhly, the court noted that marriage is a tie between two parties. If this tie is not working under any circumstances, we see no purpose in postponing the inevitability of the situation merely because of the pendency of the reference. And lastly, the court pointed out that filing multiple and repeated cases in courts against the spouse amounts to mental cruelty, even if such cases are filed after instituting the divorce petition before the family court. Further, such conduct shows disintegration of marital unity and thus disintegration of the marriage. In such cases, the Supreme Court has the power under Article 142 to grant a decree of divorce not only on account of irretrievable breakdown of marriage but also on the ground of cruelty enshrined under Section 13(1)(1)(a) of the Hindu Marriage Act 1955. Those were the observations by the court. So what are my concluding remarks? Irretrievable breakdown of marriage is indeed a real thing, and it is quite unfortunate that such an important ground has not yet been codified in our matrimonial laws. It is high time that the legislature takes cognizance of this fact and include the same in our laws. It would save a lot of heartburning of the parties as well as their time and money. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time.